Hey, this is Alex Yoder with Pro Tip Tuesday, my favorite day of the week. And we're here again today with my favorite local real estate attorney, Ken Davidson. Ken, thank you so much for taking the time to talk to us once again.
Okay.
Unfortunately, we need to keep having these conversations. As much as I love to see you, I wish it was under better circumstances. So right now we're dealing with, in the previous video that you and I did, we talked about the CDC order and the eviction moratorium on the federal level. Now we have a Colorado order, a Colorado eviction moratorium that looks a lot like the CDC order. And I was hoping that we could kind of dig into what is that going to do, what has that already done as it pertains to the impact on landlords. And then I'll have a couple specific pointed questions for you, if you don't mind that we just jump right into this.
Sure.
Yeah. So maybe you can just give us an overview real quick of sort of the period of time that this is going to affect as it stands, knowing that the governor is probably going to continue to renew that, but the period of time that this is going to affect and what the order basically says.
Right now, the order runs until November 21st, but I think everybody acknowledges that he's going to extend it to the end of the year because he's tracking the CDC order. And it looks like the CDC order is going to stay in effect as well. I know the principal challenge to that was the Atlanta lawsuit, and the Atlanta court just ruled last week that they would not enter an injunction. So the CDC order is still in effect. The governor's order 227 really just tracks the CDC order, almost word for word. And basically what he did was he extended the 30-day demands that are required, applied them to everything, commercial, residential, it doesn't matter. And then on top of that, he said that if the tenant has been adversely affected by the virus, then he tracks the CDC order on what they're supposed to do to show that you can't evict a tenant for any reason. It doesn't matter if it's the end of the lease. It doesn't matter if, they're violating the lease or doing things that are prohibited in the lease or not paying the rent. All of them are now brought under the umbrella and you are prevented from evicting. The only exception that he made was for what I class as substantial violations. And those just, where they're damaging, well, I should be more specific. It's not just damaging the property, but they're causing substantial harm to the property. They're causing harm to the neighbors or people around, selling drugs, those kinds of things create substantial violations that we can still evict for. But in the grand scheme of things, that's a tiny, tiny percentage of the number of evictions that anybody ever sees. And so basically it's just put the kibosh on any type of eviction for any reason.
So just to recap real quick, the CDC order, the eviction moratorium with the CDC was specific to non-payment, correct?
Yes, that's correct.
But his order has opened that up and is more restrictive than the federal order, which prohibits not only for any reason that you might evict somebody other than a substantial breach of lease, but doesn't it also go into basically giving tenants notices of non-renewal?
Yes, if the lease is up, if you're non-renewing for any reason, the governor's order prohibits eviction. Yeah, and the CDC order not only applied to rent evictions, but only applied to residential. And the governor's order applies to both residential and commercial tenants. It doesn't matter.
Okay. Can we talk just for a minute about late fees? Right now, late fees are a no-go, correct?
Yes, he prohibited late fees again. And this time he even modified the language so that he provided that you can't charge late fees until after December 31st. But then on January 1st, obviously you've got a whole raft of tenants that are going to be behind. You can't now start charging late charges on the money that's behind. That you can only charge late charges as of January 1 on monies that come due January 1 or after. You know, he still says, you know, I thought it was really generous of him to provide that the tenants still owe the rent. You just can't do anything about it.
Super generous.
Yeah.
Wow. Now, you made a comment about the Atlanta lawsuit. Basically, was that them suing the state, or is that suing them, the CDC?
No, there was a group of landlords in Atlanta at the end of September that filed a federal court lawsuit, and the CDC is located in Atlanta, as I think is why they filed it there. But challenging a whole raft of things, that it was not constitutional, that it was an illegal taking, that they just didn't have the authority to do what they were doing. And they were asking the court to enter a temporary injunction which prohibited the enforcement of the CDC order. If that had been granted, then the CDC order would have just gone away. But now it doesn't matter, because with the governor's order, it's worse than the CDC order. And that's the Atlanta lawsuit wouldn't have affected the governor's order one way or the other.
You know, when I first saw this thing come out on the state level, it felt very much like in case the CDC order goes away, this thing is still here kind of rule. Until I got into reading more about these more restrictive requirements. So maybe it's a combination of things, you know, not only a protection against the CDC order going away for Colorado folks, but also to add in an additional level for those people who are otherwise violating their contract. Like you said, that is a very small percentage of people. I can't honestly tell you that I can't remember the last time that we've ever had to evict somebody for reasons other than non-payment. Because I know it can be problematic to even try to do that here in El Paso County.
I mean, the normal was, you know, they got a dog, or and they're not supposed to have pets, and weren't smart enough to apply for an assistance animal waiver, or, you know, the other one that I would see all the time is, you know, they're growing marijuana and they're not supposed to be, obviously. But I think the governor's order, I think, and this is just my personal editorial opinion, I think he picked up on the fact that the CDC order only applied to non-payment of rent. And so we were still evicting because the lease was up, because people were violating the lease. And his order, I think, was intended to plug that gap and just basically say to landlords, it's tough. You can't get rid of your tenants, period. And that's where we are right now.
Yeah, it's so ridiculously imbalanced, in my opinion. But okay, so let me ask you a question. Do we know yet what the courts will do if for example, a notice of non-renewal was issued prior to the order? So let's say we gave notice in September for a tenant's lease that's ending the end of November. If they don't vacate, would we be able to pursue eviction, or is it anybody regardless of when the notice was given?
I think the governor's order, he didn't make it retroactive, but it's worded as such that it says you cannot initiate or file an eviction, period. And so even though you have a notice that may date back to June, July, whenever, you're still prohibited from filing the eviction. And on top of that, he directed that the sheriff can't serve writs. And so all of the writs that were in the pipeline on cases that we had done and completed before his order took effect were canceled. The sheriff just canceled and sent them all back.
Even if there was no declaration?
Well, the problem is, and I get that question from clients all the time, because the governor's order says if the tenant files the declaration, and I refer to the declaration as either the CDC or the DOLA declaration because they're identical. And in fact, the governor said, if you don't want to use my DOLA form, you can use the CDC form, and it's the same. But they're supposed to file the declaration. Well, they can file the declaration anytime. And when I mean anytime, I mean anytime. They can file it before we start the eviction, they can file it during the eviction, or they can file it when the sheriff is standing there ready to put their furniture out on the street. And the sheriff carries those with them and now asks the tenant, do you qualify for, well, I don't know if this is how they word it, but do you qualify for the protections that are provided by the CDC and the governor? And if the tenant, they'd have to be so stupid that it's impossible to imagine. They always say yes, and the sheriff hands them the form. And all they have to do is say to the sheriff, I'm going to file this, and the sheriff cancels the writ. And now under the current order, the magistrate has basically been issuing a blanket order that just canceled all the writs, assuming that the tenants were going to file the declaration. And
so they're not even waiting for the tenant to be that stupid. They're just voluntarily canceling them all.
They're just assuming that they're going to do it. And the problem is, I could still file an eviction for you, but you're going to pay for the eviction and go through the whole process, and then nothing's going to happen. They're not going to grant it. The sheriff won't serve the writ, and you've got nowhere. Because the court is asking them, do you qualify? And if they do, they send them downstairs to file the declaration.
Well, that's news to me, because in my mind, I was thinking, okay, if we have a situation where they do not give us a declaration of any kind, 70% of them don't show up to court, you get a default judgment. In my mind, maybe they don't show up to the physical eviction. And so in theory, you could still get a physical eviction. But what you're telling me now is that even if they don't give any declaration, the sheriff's office is automatically making the assumption that they would if they had the opportunity, and they're just canceling evictions?
That is something that we could argue, but the only way you're actually going to get the tenant removed is, it would have to be for reasons other than rent, because if we were to file an eviction with a rent demand, the magistrate automatically says, okay, this is a rent demand, the sheriff, you can't serve the writ. But if anytime, they will allow us to challenge the veracity of the declaration. We have not yet done that because nobody's ever has gotten that far. But I think in all likelihood, unless the tenant just admits under oath that they're lying and that they haven't done anything, or that they're not affected by the virus, that the magistrate's going to deny the request. Initially, they were just carte blanche dismissing all the evictions. And not myself and some of the other attorneys that are doing lots of evictions started to argue that and saying, they're supposed to at least show that they've been financially affected by the virus. And if you dismiss the eviction, we don't have any opportunity to argue about that. And so the court backed off on that and said, okay, then we'll set it for hearing. But it really doesn't provide very much relief for landlords.
Oh yeah, that accomplishes nothing if they show up for hearing, and if it's for non-payment and they don't give it a declaration, they're telling the sheriff's office not to enforce it either way.
Pretty much, because they're saying it violates the CDC order. And, again, it's one of those things we could probably argue that they haven't filed the declaration, but then they're going to set it for hearing and send a notice to the tenant. And, and of course now under the governor's order, you have to send the tenant either at the time of the demand or when we file the eviction. The CDC order and the governor's order now requires we have to send it in English and Spanish and send them the declaration. So again, they're just getting peppered with, here's the declaration. If you don't want to get evicted, just sign here. And that's what they do.
Okay. So in theory, we could set it for hearing, and in theory, they could not show up and we could make the argument that they haven't given us a declaration.
Yes.
And then in theory, they will not read anything and we show up and they will not be there and we could still evict them.
Yes. Yeah.
Okay. All right. I know that's a lot of hurdles, but that's just
A lot of theory. Yeah.
a lot of theory. Oh man, what a time to be alive. Okay. So that gives us a lot of clarity. And again, the last time we did a video, we talked about cash for keys, cash for keys, cash for keys. I don't know what other tools we have in our tool belt other than cash for keys right now, or rolling the dice on a lot of theories. So I guess we'll just see kind of how it goes going forward.
Yes.
Yeah.
Yeah.
All right, Ken. Well, as always, thank you. Oh, I'm sorry. Did you have something else you wanted to
I
add?
was just going to say it is almost a certainty that the governor is going to issue a new order in the middle or end of November. And how far, what he'll do to us, the only thing he hasn't done yet is required landlords to pay tenants to live in their property. And so how far he'll go with the next one is anybody's guess.
Jeez. All right. Well, we'll keep everyone tuned on what's going on, as we always have on a weekly basis. Very grateful for your time, Ken, and for your contribution to kind of get the word out to the landlord world here in Colorado Springs. And have a good rest of your day.
Okay. You too.
Thanks. Cool.